And the question is that this bill be now read a second time, and I call the member for Curtin.
Thank you, Deputy Speaker. I rise to speak in support of the amendments to the Family Law Act, which I believe will make the system more accessible to those who need it and will make sure that the safety and security of children is put first. Family law is a highly adversarial, emotive area of law, and no area more so than Part 7 of the Act, which deals with children. The families who look to the Family Law Act for guidance or end up in the family law courts are often angry or grieving or both. And it's a time in a family's life when they need clarity and compassion. But over time, Australia's family law system has become more complex, convoluted and confusing for any family that has the need to use this area of law. The purpose of the Family Law Act 1975 is to assist families in dispute resolution and look after children involved in family breakdown. The law is there to ensure children are protected from harm, they're supported after a family separation, and that decisions are made in their best interests. However, the complex, costly and time-consuming system does not always provide a supportive and welcome place for children, and according to the Centre for Excellence in Child and Family Welfare, children often remain voiceless and lack autonomy over decisions made in their best interests. Now, while only 3% of separating families get to a point that they need to have parenting arrangements determined by the court, so many other separating families and lawyers rely on the family law to mediate their own arrangements. Now, if we want a law that can be used by anyone who needs it, we need clear and concise legislation. Shortcomings of the current family law system have been in 12 reports since 2009, most recently the 2018 Joint Select Committee on Australia's Family Law System and the 2019 inquiry by the Australian Government Law Reform Commission into the family law system. So with this background, I'm pleased to support any reforms to the family law system that make it a better, easier, fit-for-purpose system that works in the best interests of the child. And this amendment bill does some really good things. This bill intends to place children's rights in the centre of the family law system and to give them an increased voice in decision-making. It simplifies the factors considered in the best interest test. It expands the notion of family. It gives increased weight to connection to culture for Aboriginal and Torres Strait Islander people. And importantly, it amends Clause 60B, which has led to confusion about a presumption of equal time. I welcome the amendments aimed at ensuring the best interests of children are placed at the centre of the system and its operation. While this has been the intent of previous iterations of the Act, these amendments make it clearer. The simplification of the Objects Clause in Part 7, Children, according to the National Children's Commissioner Anne Hollands, more comprehensively gives effect to Australia's obligation to protect the rights of children. This is a good thing. The amendments to Section 60cc, which outline how a court determines what is in a child's best interests, are also positive. Previously, the Family Law Act drew a distinction between primary considerations and additional considerations. And I note several stakeholders have raised concerns about removing the previous hierarchy of interests because it could give judicial officers too much freedom in interpreting and determining the best interests of the child. However, I believe that removing a hierarchy of considerations gives judicial officers the appropriate flexibility and the ability to weigh up the safety, needs and anything else that's relevant to the particular circumstances of the child. I particularly support the addition of a directive for a court to consider the rights of an Aboriginal and Torres Strait Islander child to have the opportunity to maintain their connection with community, culture, country and language. And as the WA Aboriginal Family Legal Service said in its public submission, this clause is a key mechanism to ensure that a child's Aboriginal and Torres Strait Islander status, cultural rights and other cultural issues are brought to the attention of judicial officers. And I will be supporting any amendments that also require cultural and linguistically diverse children to be afforded similar considerations. The WA Aboriginal Family Legal Service also welcomes the introduction of an extended meaning of member of family to recognise Aboriginal notions of family and kinship. I do note, however, that the proposed definition of family in this amendment differs from the definition of family in the Children and Community Service Act 2004, which may cause future complexity. And finally, I support the clarification in the amendment that makes it clear that there is no presumption of equal time under Section 61DA of the Family Law Act. Now, while equal shared parental responsibility was not intended to be a presumption of equal time, it has been interpreted like this, potentially detracting from a focus on the child's best interests. And the way this was drafted was confusing. The Youth Law Australia Centre at UNSW said, "In our experience, the confusion surrounding the presumption has led to many families agreeing to unsafe care arrangements in cases resolved by consent." And while I appreciate that it is in the child's best interest to maintain personal relations and direct contact with both parents on a regular basis, it should not be assumed that this means equal time between both parents. It's imperative to raise community awareness about this change, including specific training for legal practitioners, family dispute resolution practitioners, family counsellors and family consultants. I also support the Family Law Amendment Information Sharing Bill. The ALRC review found that improvements are required to judicial gaps within the family law system, which in part is because family law is segregated across state and federal legislation. The family law system remains confusing and traumatic for many who go through it at an already vulnerable time. We need to keep improving this system to make it simpler, fairer, and focused on supporting children and their parents in a difficult time. These amendments are necessary and important. I commend the government for actioning the recommendations of the ALRC review. Thank you.